Hi there, this is Jonathan Ginsberg, and I'd like to answer a question that I get sometimes from my clients, and that question is, can I dismiss my Chapter 13 if I decide I don't want to go forward with it? And the situation might be that you go into a Chapter 13 and you realize that the information being requested is too invasive, or for whatever reason you decide that Chapter 13 is not the right solution for you. Can you simply dismiss it, or what are your options? And generally the rule is that yes, you can dismiss a Chapter 13. Unlike Chapter 7, where dismissal has to be sanctioned or approved by the court, in a Chapter 13 you can basically walk into court and say, I changed my mind, I want to dismiss this case, file something called a voluntary dismissal of Chapter 13, move on about your life. However, there's some qualifications to this, and I want to emphasize that if you do think you want to dismiss your Chapter 13, you should always do so with the guidance of a lawyer. Now, there are a couple of situations where you can't dismiss a 13. It's fairly rare, but it does happen, and I've actually had cases over the years where it's happened. One situation might be if you file Chapter 13 and you really have sort of marginal basis to make it work. For example, if your income is very speculative and you file the 13 to protect a valuable asset. So for example, if you filed a Chapter 13 self-employed, you've got a piece of property or some sort of an asset worth several $100,000, you file a 13 to stop a foreclosure, but the 13 is not really all that feasible. The trustee might go in and file a motion fairly quickly after your filing to ask the court to issue an order that says that you cannot voluntarily dismiss without permission of the court. And trustees do this because realize that part of their arsenal, part of the things they can do is they can move the court to convert your case to a Chapter 7. So if a trustee feels like your case is marginal or perhaps filed in bad faith, the trustee can go to court and ask the judge to issue an order disallowing a voluntary dismissal. Now, realize if you voluntarily dismiss, and you might be able to do so, there could also be repercussions, and these are things that you want to speak with your attorney about. For example, if you file a voluntary dismissal and you have previously, there's been a motion for relief from stay in your case, meaning that a creditor has filed a motion asking the court to lift the stay. If you dismiss the case voluntarily, you cannot refile for 180 days from the time of dismissal. So basically, there's a 6-month bar to refiling. You're not even eligible to file. I think the reason that this is in the code is that Congress wanted to prevent people from filing repeat cases to frustrate the aims of creditors and stop foreclosures. In other words, somebody has a foreclosure, they file a Chapter 13, a motion for relief is filed, a debtor dismisses the case voluntarily, then goes back and refiles. So you can't do that. So that's a situation where you would not be allowed to refile after dismissal. You can dismiss, you wouldn't be allowed to refile. And of course, the second situation, which is a newer situation as of 2005, is that the automatic stay may not apply, or may apply on a limited basis on a refile. So for example, if you voluntarily dismiss your case, or in this situation, if it's dismissed involuntarily, dismissed by order of the court, but if it's dismissed in any respect, and you refile your case within a year of case number 1 being pending, the automatic stay will only go into effect for 30 days, and you have to go to court and ask the judge to extend it, and you have to show there's some reason why the judge should extend it. If it's your second case pending within a year of a prior case, in other words, there's been one case dismissed, a second case dismissed, now this is your third or perhaps fourth case, the automatic stay does not apply at all. And you have to go to court to ask the judge to impose it. And again, what these automatic stay issues were designed to do is to stop serial filers, stop people from filing case after case after case, to avoid foreclosure, and to live in a house for free for an extended period of time. So bottom line here is you can dismiss a Chapter 13 voluntarily. You have to make some real thoughtful choices about whether you want to do so and whether or not you should you may want to pursue another case. I've seen situations where it may make more sense to let the court dismiss the case by stopping funding and so forth. But these are strategies you would want to talk about with your attorney. But bottom line is be very, very careful if you think about dismissing a case. If you do feel you want to have it dismissed, by all means do so with the guidance of your attorney. So this is Jonathan Ginsberg, and those are my thoughts about voluntarily dismissing a Chapter 13 and the implications thereof. Any questions, give me a call, drop me an email, be happy to discuss them with you. And so that's it for now. Thank you.